Black man say you for
Hi, what's your name, please?
Mandel Wilbur Berryman. What do they need? No.
All right, Mr. Berryman, you have some traffic misdemeanors where you missed court dates. When you missed your court date, the judge assigned to the cases, issued warrants, they set bonds. We're going to set the warrants aside today and give you personal bonds on the tickets. You have the right to remain silent. You're being recorded. Anything you say could be used against you in the future. You also have the right to have an attorney represent you on the tickets. If you can't afford an attorney, one will be provided for you on or before your next court date. These are misdemeanors for which the maximum possible penalty is up to 93 days in jail and or a $500 fine. Ticket number 701370 alleges January 10th of 2022 at Huber and St. Cyril that you had no operator's license and no insurance. 473262 alleges February 8th, 2018 at Harper and Meringue, no operator's license. 495728 alleges July 11th, 2019 at Charleston, Nevada, no operator's license. P1147597 alleges December 28th, 2020 at Chrysler in East Warren, driving while license not valid, driving an unregistered or untitled vehicle and no insurance. P1171662 alleges March 3rd, 2021 in the area of Connor and Charlevoix, driving with an expired driver's license. And P1382737 alleges August 24th of 2022 at East State Fair and DeQuinder, driving while license suspended and no insurance. On all of these, sir, you will have the same court date and the same judge. You'll have pre-trial July 21st in front of Judge Yancey. Now we'll go to your other matter, which is case number 230-573-3102, People of the State of Michigan versus Mandel Berryman. Counsel.
Good afternoon, students. Good, now, Lieutenant Bird, on behalf of Mandel Berryman, client waives the right to formal reading inside the constitutional right.
Thank you, counsel. The court notes formal reading has been waived and enters a not guilty plea on your client's behalf. I'll hear your arguments as to bond.
Thanks, Judge. In this matter, the people are going to be asking for a $50,000 cash and surety bond. If the defendant were to find out, we would be asking for a GPS tether, as well as home arrest and no contact whatsoever with the individuals involved in this. Your Honor, this case has to do with the 1-year-old who ended up getting shot in the face. The 1-year-old had to have reconstructive surgery, as well as surgery to the shoulder. The residence where the shooting ended up taking place was at defendant's house. Defendant knew that he shouldn't possess or have a handgun at his residence. Reason being, Your Honor, the defendant had previously been convicted 4 times over. Your Honor, there's, and I'm sure as Your Honor saw in the investigative report, there were multiple children inside of a house. They ended up getting a gun, which allegedly the defendant, one in this matter, had stated who was in a lockbox bed. We have forensic investigation interviews with the children who testify differently, who ended up finding it on a shoe. And Your Honor, I believe one of the individuals, the cousin, saw this on the shelf. Somehow it got in the hands of another one of the cousins, and ultimately, Judge, what we have here is a 1-year-old who ended up having to go through multiple surgical interventions. Your Honor, just for the allegations, let alone the fact the severity of the incident, this is assaultive in nature, kind of unique. We've been hearing about these kinds of stories lately. Judge, unfortunately, this is just adding on to that list. The people feel justified in stating that the defendant is a danger, Judge, and as well as asking for the cash bond and GPS tether.
Okay, thank you. I can't read.
I'm sorry.
Okay.
I'm sorry, Your Honor, and I just asked defense counsel if I could just say one more thing, just so it doesn't have to come back to me. As Your Honor will see, in the report, it's basically on the second to last page, Judge. This defendant apparently has had multiple run-ins with CPS cases. These CPS cases, as it's stated, have been substantiated and is currently on the central register.
Okay, thank you. Hold on one second. Yes.
Very important. Mine is very 50-year-old lifelong resident, 5 children, living with his wife. We think that the non-professional role has no cases. He is employed for the family side of his, well below the 20% property guideline. Any amount of violence would like to remand to my client county. He does have medical problems. He was born with 1 kidney county. The commercial found negative is very much appreciated. When it comes to this situation, y'all, my client indicates to us that he was working in the backyard. As we can see in the report, working in the backyard, 5 children in the house. He indicates to us that that's not his gun. It's not his gun, y'all. So even in the constructive way, I believe my client, not my client. We heard Brother Counsel state that his co-defendant actually said that gun was in a safe, that gun was locked in a safe under the bed. The gun's in the co-defendant's name, y'all. So it's not my client, not like my client had a gun on him. It's not like we have any witnesses that say they seen my client handle the weapon. They never, we don't have any witnesses that said they seen my client even put it on the shelf where it was allegedly found. Where one of the children said it was allegedly found. Now, my client's not trying to run from this case. By this case, there's no way to say that my client is a threat to the community. There's no way to say my client's a threat to the community. He's not going around trying to harm anybody. He was working on his home, take care of with his children and his wife, which he works hard to keep up. And respectfully, Your Honor, I do understand the severity of the situation, and it's unfortunate that we do see situations like this. But respectfully ask this court for a personal bond in this matter.
And just for the record, the people never said that it was, the defendant claimed that it was his gun, but the defendant here on the screen knew that the gun was in the house.
And for the record, people said that he was in possession of the gun. That's almost like saying that my client, that the client was, he should have, no, people said he should have known.
One moment, please. Is this in the investigator's report that he had knowledge that the firearm was in the house and where it was in the house?
Yeah.
Okay, where is that, please?
Your Honor, I have on page, I don't know, Your Honor, where it speaks to the about halfway down the first paragraph. It talks about how
Okay, thank you. I'm looking at it now.
yeah, where it says the father made it known multiple times he had assumed the gun was locked in the lockbox underneath the bed.
So you've got him, you're telling me he has 4 prior felonies. I'm not seeing them. I was looking for what they were.
I got the previous, pulled out.
What are they, please?
Yeah, there are 2 different drug charges. We have RNO, and then we also have an additional drug charge.
Okay.
But he wasn't charged with that.
No, I know.
But
That's why I'm asking.
Now, those convictions or charges?
Convictions. But Your Honor, just to answer your question on that page, he specifically stated to police he was aware that the firearm was in his home.
Okay, one moment, please. I mean, in some ways, I'm evaluating this like I would any other, like a DV charge, right? Not that he's a danger to the overall community, but how much danger is he to the people in his own home? But in a typical DV case, I have somebody who willingly engages in assaultive behavior against someone else, which I don't have here. This is careless, if it's true. But I don't believe it's something that defendant wanted to have happen.
As Your Honor can see, this is a pretty extensive investigative report with multiple interviews with, it appears as though all parties, I think just, Your Honor, just to emphasize the point that with their extensive investigation, made it a point to put in the fact that there were other additional CPS cases that this defendant was previously involved in. So I can appreciate what Your Honor has to say about the defendant not wanting this to happen, but it appears as though this potentially could be some type of repetitive behavior.
All right, I'm going to ask you guys to just give me a few moments. I'm going to take a little bit of time with this investigator's report. It is lengthy. I'm going to just take some time with it. Just give me a moment. You know, part of what troubles me here is the allegation that one of the children was interviewed and stated that they heard another child tell this child to get the gun. They then saw him stand up on a chair to get the gun that was on the black thing in the food area. He then got down from the chair and he had shot the other child. And so it's difficult for me to believe that multiple children in the house know where this gun is and know that it's accessible. But defendant who lives in the home, another adult living in the home who can see that shelf doesn't. And so then that brings me to, is there a danger created by him being in the home with these kids? That coupled with prior CPS cases that are cited here, and it gives me no information that I can see really, and it is a lengthy report, so perhaps I've missed it. But it does tell me that there are substantiated CPS cases listing on the central registry, but no prior removals. So it does say there have not been prior removals. But this has now culminated in severe injuries to a child through what seems to be sheer carelessness. There are no prior convictions used to enhance, although he is charged with felon in possession. I was looking for that because I don't even see what they are because they weren't used to enhance. But so now we've got somebody who I believe knows they're not supposed to be in possession of a gun or in a house with a gun. Looks like if the other kids knew there was a gun there, hard for me to believe he doesn't know there's a gun there, had not taken steps to secure it. I understand it's someone else's gun in the house and she's saying it was in a lockbox, but it's just difficult for me to believe just from this. And I'm not, he's not on trial right now. The only thing I'm trying to understand is if he goes home, what kind of danger does that pose? Is this kind of carelessness likely to happen again? Is something like this likely to happen again? And quite frankly, if you know you're not supposed to be around a gun or have a gun in your possession and you have it in your house anyway, Why should I believe that something like this might not happen again? I don't. Just in the time it takes to get the case to the next step. Okay, it's going to pick up. It'll pick up whatever you're saying. So make sure you want it picked up. Okay. All right. Yes.
One thing out of the report, one thing this report does show, I do understand one thing the report does show that my client was never responsible for handling that weapon. By the comment that he made, in the initial confession, first of all, everything that I see is the co-defendant that talks about how she hired, how she used there's one statement that she assumed they hid it. She assumed that the children hid the gun from where she placed the gun. Also, where it says to me statement she had seen the gun marked, which she put it on unloaded tip, and that she knew the gun was on the shelf. Well, my client has been working out, we don't know the story yet, but my client has been working out in the backyard, so the thing came in, and place, put that gun anywhere. It doesn't show where my client was ever responsible for handling that weapon and putting the kids in danger because of that weapon.
All right, that being said, I will say there is one other statement in the investigator's report that does concern me. And that is the same child that was interviewed said that Mr. Berryman came into the house and stated someone needs to put that gun up while her aunt was still there. She stated that he then went back outside and the aunt left the house to cook, stated they were all told to go to the bedroom. So she assumed they hid the gun somewhere. And they later told him to get the cuffs off the shelf, and that's when he must have found the gun. So I don't know. You know, there's a lot here that concerns me about how cooperative folks are going to be. That goes to flight risk. There's concern about the priors, knowingness of the gun there. I'm going to set bond in the amount of $50,000. I am going to set it as a cash surety bond. Additionally, though, during the course of this bond or until a judge says otherwise, there will be a GPS tether with full home confinement. And under that tether, while he's on home confinement until a judge says otherwise, he's not to reside with any minors. That can, of course, be taken up at the next court date on Tuesday. Tuesday morning. That's going to be, what's my date? Tuesday morning. Where are we? We're at
20th. June 20th.
June 20th. All right. So this will be up for bond review hearing on June the 20th. June 20th in front of Judge McConico. You can, of course, address the amount of the bond and my bond conditions, which are the GPS tether with home confinement and no residing with minors. After that, court dates are going to be July 5th for probable cause conference, July 12th for preliminary examination. The prelim is set for 1:45 p.m. Both are set in front of Judge King. And Mr. Berryman, you are not to purchase or possess any firearms or other dangerous weapons during the course of this bond or to be in a home where they're found. That's part of this, part of the deal. All right, thank you.
I just spent my gun. But now what I do? I get a 50 cash or what?
All right, thank you for waiting. What's your name, please? All right, Ms. Morgan. This is case number 230-573-3101, People of the State of Michigan versus Lolita Morgan. Counsel.
Judge, good afternoon. Steve Benson on behalf of the people.
Yes, Your Honor, Brandon Bird on behalf of Lolita Morgan, my client waives her right to
Thank you, counsel. The court notes formal reading has been waived and enters a not guilty plea on your client's behalf. I'll hear arguments as to bond, noting that Ms. Morgan is the co-defendant in the case involving Mr. Berryman, the shooting of the one-year-old.
Judge, that's correct. She's the first of the two defendants listed on the complaint. For the most part, Your Honor, the people would just argue the same alleged facts that occurred, but for a couple of things, Judge. It was Miss Morgan whose gun was used in this particular matter. Your Honor, I believe that in the investigative report, we'll find that she confessed to that or admitted to that. As well, Your Honor, the people would like to note that there was some discrepancy in terms of allegedly what Ms. Morgan said to the police officers. Originally, upon investigation, she had told the officers that her gun was locked up in a gun safe. And she actually said that 2 or 3 times. Then subsequently, apparently in that same investigation, she ended up telling the police officers that the gun was on the shelf. And as we know now, based on all of those different interviews from all of the children forensically and otherwise, that it actually was located on the shelf, Judge. With all of that being said, and I know Your Honor is well aware of everything else that was listed in the investigative report, the previous defendant, I believe, was issued a bond in the amount of $50,000. $50,000 cash surety, Judge, with the GPS tether and home arrest. That, I believe, Judge, was in a lot of part based on the alleged facts, as well as the previous convictions, and there were some issues regarding domestic issues previously. And I think we established the fact just based on the allegations that he wasn't the owner of the gun. Now we have the owner of the gun who allegedly, Judge, was disqualified to have a CPL. So with that being said, the people are going to be asking for the $50,000, just like this court issued with the other defendant. We do feel that she is a danger.
Thank you.
I do want to say for the record, nothing's actually true. As like right now in this matter, everything is allegations and alleged in this matter, regardless of whether or not the issue is here. So before you know one thing, we do have a 1-year-old young. We just crazy. My client looks good, and of course, 20 years old. I'm pretty sure she's suffering from herself. For whatever happened, it's got to be sorted out next week.
A lot of these relaxing commercials aren't today.
We'll blow 200% from guidelines. Won't be able to afford any amount of buying there. Unfortunately, not sure what's about to happen with the kids at the time, to be honest. We just live in the house. We're behind mine. Not accepting any of these allegations to be true. You use the word allegations for us to be true. It doesn't look like anything in the future. And strictly may ask us for a petition for personal time, personal time, so personal time. The reading of the petition bonds.
Thank you. I mean, I understand your argument, counsel, that we don't know what's going to happen to the kids if they're both given cash bonds, but at the same time, I have kids in a house with adults who are carelessly leaving firearms around such that one of them ends up shot in the face, and thank God he survived. And so I do understand your argument, but again, you know, just like I said with Mr. Berryman, what I have to try to determine is there a safety risk posed to the kids by the defendant being there and engaging in kind of careless activity? Now, I don't have the prior CPS involvement with respect to this defendant that I had with Mr. Berryman. I don't have any allegations that there's prior CPS involvement. It does concern me that there was a disqualification as to the firearm. I don't know why. It doesn't tell me why, but it does say that she was disqualified. And so again, I've got folks that know they're not supposed to have guns having guns. And then She was disqualified from having a CPL. She did have the gun registered, but not had it placed, safely away, obviously, in a way that could not be accessed by the kids, numerous of them in the house. But I don't have the prior CPS involvement, so that's not as much of a concern for me there. CPS investigation is already ongoing as to this case, so they'll determine in terms of whether the kids are safely at home or need other placement there. I mean, it just, it's just troubling that this just keeps happening over and over again. I mean, it's it's so clear to all of us at this point that we have to be securing firearms. And then it's a danger not to do so. Kids are curious about them. They don't understand the finality that they pose if used in the wrong way. Given the lack of prior CPS involvement here, given the fact that the firearm was registered, I do have a little bit of a different situation going on, but I do still have some concern about safety. I do still have some concern about cooperativeness in the course of the investigation. Bond will be set in this one at $35,000 cash surety.
Yellow, are you gonna want some burger and bacon? Bar dog. Cheese too, buddy.
GPS tether.
Barn? Huh? Oh yeah.
With a curfew 10 a.m. to 6 p.m. if she's able to make that bond.
Is that cash?
It's cash surety, ma'am. $35,000 cash surety. The next court date's going to be in front of Judge McConico on June the 20th. That's for bond redetermination. He will look at this bond and determine whether or not, Tuesday, whether or not to keep it the same or do something different. That's June 20th. After that, probable cause conference set for July the 5th. Preliminary examination set for July the 12th at 1:45 p.m. Both of those last ones in front of Judge King. During the course of this bond, you are not to purchase or possess any firearms or other dangerous weapons. Hi, have they heard from the, no, it's okay, we've tried to reach the officer. Has there been some contact with the back by the officer at all?
I don't know, I went to the back and they didn't have any paperwork for us
Okay.
yet, so they're reaching out to Ms. Gray about it.
All right, we haven't talked to the officer. He's apparently gone for the day or something. I don't know, so we've just been able to process it.
Thank you.
All right, thank you. Ms. Morgan, you're all done. I hope justice prevails too.
Can I say something, please?
Ms. Morgan, this is the attorney Brandon Bird speaking. Can you hear me?
Yes.
I understand what you're going through. I really sympathize with you also. But at this moment, your best bet is to exercise the right to remain silent. Exercise the right to remain silent. And wait till you talk to your next attorney, either in person or confidential source. Don't talk to police, detectives, on the phone while you're in jail or anything. That's the best advice I can give you.
Your attorney has advised you to remain silent. You have a right to remain silent. He's advised you not to speak to anyone about your case other than your attorney. I'm just telling you because I'm the easiest person to hear. I've got the best microphone. So that was his advice to you, all right? He also did say he understands that you are going through a very difficult time and expressed sympathy for that, as do I. But bond is set in the amount of $35,000 cash surety in this case. June 20th, July 5th, and July 12th. You are not to purchase or possess any firearms or other dangerous weapons during the course of the bond. Thank you.